Good day everyone, welcome back to another episode in our What If series. We will bring you insights in the format of a what if question on the ever-evolving landscape of employment law. My name is Ross Simon from Maserumule, and in today's episode we will unpack what if an employee fails to report for duty following a reinstatement order. Is the employer still obligated to reinstate them? Sounds like a simple question, right? Well, the Labour Appeal Court recently had to weigh in on exactly this issue in the case of South African Municipal Workers Union on behalf of Koopman versus City of Cape Town and others. And the outcome provides valuable insights for both employers and employees, particularly in understanding their respective rights and responsibilities under reinstatement orders. Let's take a closer look. In 2014, Mr. Koopman was dismissed by the City of Cape Town following a disciplinary hearing. He subsequently challenged his dismissal, and the South African Local Government Bargaining Council ruled in his favour, ordering his reinstatement effective from February 2014, along with back pay. However, rather than returning to work, Mr. Koopman waited 8 years until August 2022 before attempting to enforce the arbitration award. He also initiated contempt proceedings against the city for allegedly failing to comply with the reinstatement order. So, what did the court say? Was the city still required to reinstate him after all that time? The City of Cape Town argued that the arbitration award had expired under the Prescription Act of 1969, which limits the enforceability of such awards to 3 years, like debt claims. The Labour Court agreed, ruling that the award had prescribed and the case was dismissed. But Mr. Koopman was not done. He appealed, saying that arbitration awards should be valid for 30 years, just like court judgments. While this argument was considered, the Labour Appeal Court took a different approach and asked, did Mr. Koopman even try to return to work after winning his case? Turns out he did not, and that was a major problem for him. The Labour Appeal Court ruled that a reinstatement order does not automatically place an employee back in their position. Instead, it establishes reciprocal obligations. Firstly, the employee must actively offer their services, and secondly, the employer must then facilitate their return to work. Failure to do so within a reasonable time frame may result in the employee losing their reinstatement rights. In this case, since Mr. Koopman made no effort to resume his duties, the court found that his right to reinstatement had lapsed, rendering the issue of prescription irrelevant. So, what should we all learn from this? For employers, reinstatement is not automatic. An employee must formally indicate their intention to return. If an employee delays their return, employers should document all communications to establish a clear record. Employers are not required to keep a position open indefinitely. For employees, if you obtain a reinstatement order, it is essential to act promptly. Failure to engage with your employer in a timely manner could cost you your job permanently. There's even talks of a possible change in the law to require employers to notify employees when all legal proceedings are finalized. So, stay tuned for that. Colleagues, that brings us to an end of this week's episode. Thank you for joining us. We hope you have found our discussion informative. If you have any questions or comments, we'd love to hear from you. You can find us on social media, or you can email me at ross@massconsulting.co.za. Until next time, bye-bye.